Hello and good evening. I'm calling the public meeting to order. Do I have a mover and a seconder? Moved by Trevor Bougie, or Councillor Bougie, and seconded by Councillor MacDonnell. Looking to approve the agenda. Are there any additions or amendments?
No, Mr. Mayor.
Okay, looking for a mover and a seconder of the meeting agenda. So moved by Deputy Mayor Lang and seconded by Councillor MacDonnell. All in favor? Approved. Any declaration of pecuniary interests? Seeing none, let's get into new business.
Thank you, Mr. Mayor. We have two public meetings this evening. Before we get started, I am required to read some wording under the Ontario Planning Act. So this is a public meeting under Section 34 of the Ontario Planning Act. Any person may attend the public meeting and or make written or verbal representation either in support of or in opposition to the proposed zoning bylaw amendments. If a person or public body does not make oral submissions at this public meeting or make written submissions to the Council of the Township of South Glengarry before the bylaw is decided upon, the person or public body is not entitled to appeal the decision of the Council to the Ontario Land Tribunal. If a person or public body does not make oral submissions at a public meeting or make written submissions to the Council of the Township of South Glengarry before the bylaw is decided upon, the person or public body may not be added as a party to the hearing of an appeal before the OLT unless there are reasonable grounds to do so. So the first application we have this evening is known as the MacLachlan Bylaw Amendment. This property is located at part of Lot 6, Concession 1, in the geographic township of Lancaster, now in South Glengarry, and it's known as 6239 Sarah Drive in MacLachlan's Point. We do have a map that shows the subject property. This is the area that's highlighted in black. It's located the second one in from the St. Lawrence River, and this would be the entrance to MacLachlan's Point, which is comprised of 4 public roads going south and 1 this way. So the purpose of this amendment is to rezone the subject property from floodplain holding to limited services residential exception 11 and floodplain holding to permit a proposed residential garage to be the main permitted use on the subject property. Also to reduce the front yard setback from 6 meters to 2.44 meters and to reduce the watercourse setback from 30 meters to 6.09 meters. If this bylaw is approved, all other provisions of zoning bylaw 3809 as amended shall continue to apply. The applicant obtained a demolition permit to demolish a cottage and a bunkie. That cottage and bunkie had been on this property for many, many years and was becoming a little derelict. And that cottage and bunkie was actually located closer to the front property line by approximately 0.5 meters and closer to the canal or the watercourse by approximately 5.15 meters than the proposed garage. The applicant obtained a topographic survey to determine the existing elevations of the property. The proposed garage will remain in the floodplain. There was a portion of the property that was out of the floodplain, but not necessarily exactly where the garage was proposed to be built, but primarily it is in the floodplain. And with the proposed garage replacing an existing cottage, it's actually improving the situation as the garage is not an habitable structure and it is proposed to be further away from the front lot line, and the watercourse setback than the original cottage and bunkie was. The subject property is currently a designated rural district in the county official plan, and the proposed amendment conforms to the official plan and the provincial policy statement. This survey, I understand, is very difficult to see, so I tried to highlight some measurements. So, as I mentioned, with the reduction of the proposed setback would be from 2.44 meters. If you look at this outline here, that was where the original front entrance or front porch of the cottage was. And then this outline here was where the original cottage was with the bunkie attached. Wasn't necessarily attached, but they had boards kind of making it connected. So when you looked at it from the front, it looked like it was one structure. And then at the back, the original cottage came out much closer, and now the proposed garage is going to be 6.09 meters. And again, the cottage was closer simply because of the back porch. So to date, we've received no written comments. I've not received any phone calls, any comments from the public whatsoever. We have circulated the application to the Raisin Region Conservation Authority. At about 4 o'clock this afternoon, I had not received any comments yet, but they came in at about 4:38 this afternoon. So Here I have it written that we've not received their comments, but they were heavily involved in pre-consultation, really from the very beginning. Before Mr. MacLachlan chose to apply for a demo permit, he did meet with us to understand what his options were, what his restrictions may be, what his grandfathered rights may be, which is really important. We always encourage people to do that because we don't want to see them, proceed with demolition too quickly and then maybe losing those rights. So the Conservation Authority was involved all along, and in fact, we did receive their comments later this afternoon, which I mentioned, where they have no concerns with what's being proposed. In fact, they encourage Mr. MacLachlan to proceed with the application to create or to look for permission to have a garage as the main use. This property is quite small. If the zoning amendment is approved, there'll be no space to accommodate a dwelling. There would be no space for a dwelling, a septic, or a well. This will be the only use for the property. Mr. MacLachlan lives directly in front of the lot. The property is, I believe, family owned, so not interested in merging the parcels of property. And so this is why they're looking for that site-specific amendment. This application will be subject to a decision of council, and my intention is to bring it back to council for December 5th. For a decision at that time. So if there's any questions, Mr. Mayor, I'd be happy to answer them. Mr. MacLachlan is here this evening as well. He could probably provide more details in regards to the proposed construction. Thank you.
Okay, thank you. I'll look to council and the public if there are any questions, or and Mr. MacLachlan as well, if there are any questions or anything of discussion, please go ahead. Yes, please go ahead, Councillor Jaworski.
Okay, thank you through you, Mayor McDonald. Thank you. Question for Ms. Haley. I wonder if you could just repeat or go into a little bit more detail about, you said the future for the property, once this is there, that you're saying there's no room for this or that. If you could just repeat that or expand on that a bit, please.
Sure, through you, Mr. Mayor. If we can refer to this image on the screen, you'll see the proposed garage is to be located in the area that's somewhat grayed out. There's very little space left available that would be large enough to accommodate a building envelope and a septic system and a well. So there's no ability to develop any residential unit on that space. If it's approved, it'll only be this garage.
If I may supplement, but it's still staying completely separate from the lot beside it, right? There's
That
no
is correct. They're
merging.
individually owned with their own separate PIN, different family names, or different family members.
Okay, thank you.
Councillor McDonnell.
Maybe not. Through you, Mr. Mayor, I guess just a comment I'll lend to the application is I spent quite a bit of time down there as I formerly owned a property on the very corner of Sarah and Cedar. In my opinion, be a great improvement to what was there. To say the cottage that was there was inhabitable and there was really beyond repair. So I think it's a great solution for the entire street, is in my opinion. But thank you.
All right, I don't see any comments from council. Any comments from the proponent or the public?
Well, I would concur. I think it would definitely be an improvement to what was there.
Okay, great, thank you. Shall we then move on to the second zoning amendment under new business 4B? The zoning amendment is cannabis production and processing. And I'll give it to you, Mrs. Haley.
Mr. MacLachlan, you're welcome to stay for the next presentation, or you're welcome to leave. It's up to you. Okay, thank you, Mr. Mayor. We'll move on to our next topic for this evening. The purpose of this amendment is to amend our zoning bylaw 3809 to regulate cannabis production and processing facilities. So I'm going to go through a variety of details of information that we had to consider, or we have to consider, to amend the bylaw, and what the proposed recommendations will be, and what the general provisions and permitted uses will look like if this amendment is approved. So I'm going to start off with talking about the governmental framework. So we all may recall that the federal government decriminalized cannabis in 2018, and Health Canada oversees all licenses for cannabis facilities. Provincial governments were made responsible for distribution and sales of cannabis products, which really is separate from our goal in amending the bylaw this evening. So many municipal governments are still responsible for implementing policies and regulations for land uses, including where cannabis products can be produced, cultivated, processed, and sold. In November 2020, South Glengarry Council passed an interim control bylaw to provide time to allow administration to conduct a land use study to examine the land use impacts and methods of regulating the cultivation, production, and processing of cannabis within South Glengarry. There was a period of time where we did experience a couple of locations where cannabis production popped up in different locations where they weren't permitted. And so this allowed us to put the interim control bylaw in place, which means it suspends the ability to create these types of facilities until such time we've done a proper review to determine where they should be located within the township. So our interim control bylaw was approved, as I mentioned, in 2020. It was extended in 2021, and that's because the Ontario Planning Act allows you to put an interim control bylaw in place for a maximum of 2 years to provide adequate time. And that bylaw just expired on November 16th of 2022 of this year. So the Township of South Glengarry is working towards updating our zoning bylaw to regulate cannabis production, cultivation, and processing. And this will also be consistent with a recent official plan amendment that the United Counties has passed regarding the same topic. So our land use study was conducted and completed in October 2022. I did retain a consultant to pull together this study to look at what was being done throughout the United Counties as well as elsewhere in Eastern Ontario. There was some great work done by 2 of the other municipalities in SDNG and some outside of the United Counties that were looked at. So the study considered the legal framework in Canada, the municipal regulations in Ontario, and a variety of literature regarding cannabis regulations. So the Cannabis Act has legalized limited personal growth of cannabis for personal use and has set out a framework for regulating the production and sale of cannabis products in Canada. So I think we all know that every resident in Ontario is permitted to have up to 4 plants, and it's a maximum of 4. If you have more than that, then you are required to have a medical marijuana license or medical cannabis license. And then beyond that, you're now getting into licensed facilities with Health Canada for a much larger production. There are 5 classes of licensing at the federal level. This might be hard to read, but I apologize for that. But these licenses look after cultivation, processing, sale for medical purposes, testing, and research. And the cultivation and processing licenses are further broken down based on scale. And then individuals can obtain combinations of subclasses of certain licenses. So for the federal licensing, the first thing we look at is location. Applicants are required to provide where the site will be located as part of their application. So there's a very formal application process to Health Canada. Many of these operators of facilities retain consultants to complete their application submission because it's so heavily detailed. And there's definitely some consultants out there that are capable of submitting a comprehensive application. And if a site is proposed, they must meet all the security requirements. And so all sites for cultivation, production, and processing must have physical barriers to prevent unauthorized access, as well as intrusion detection system. Visual recording are held for at least once a year. I understand that's how Health Canada does some of their inspections. And then for micro cultivation, processing sites and nurseries do not require intrusion detection systems or visual surveillance. It really does depend on the volume of growth and the type of licensing that you have. So for air filtration and ventilation, sites where cannabis or anything that will be used as an ingredient is produced, packaged, labeled, stored, or tested must filter air to prevent odors escaping and to purify the air to avoid contamination of the cannabis. If anyone's ever been near a cannabis facility, they are quite odorous, and they do often result in many complaints from the public if, depending on the direction of the wind, proximity to houses, things like that. So air purifications must also be accessible for cleaning, maintenance, and withstand repeated cleanings as well. Also, for access to cannabis for medical purposes, a registered or designated person can produce cannabis for up to 2 individuals, including themselves, and the limit is based on the prescription of the person to receive the cannabis. So one thing to keep in mind is if you happen to be growing for yourself as well as for another individual, you still have to make sure that the site that you've chosen conforms to municipal regulations. And a lot of the members of the public don't understand that. I think they think that once they've been given a medical marijuana or cannabis prescription, they feel they can grow where they choose to, and that's not necessarily the case because you're allowed up to your 4 plants. You can't have multiple plants and then grow for others and assume that the space that you chose is automatically approved. So there's also reasonable security measures to be taken for outdoor growth, and it's to be prohibited near schools, playgrounds, daycares, and spaces, and areas that could be frequented by minors. So if, for example, an individual or a company applied for a license with Health Canada, the municipality would be notified, and we would have an opportunity to review and comment on the proximity and make sure it conforms to any policies or bylaws that we would have in place. So I want to now talk about the provincial policy. So the Government of Ontario passed the Cannabis License Act in 2018 that created the framework for the retailing of cannabis products in the province. The provincial government has removed the authority of municipalities to address zoning for the retailing of cannabis products through the Cannabis License Act. However, municipalities can currently regulate the zoning for cultivation, production, and processing of cannabis. You may recall a few years ago, our municipality was given an opportunity, or every municipality in Ontario was given an opportunity to, they called opt-in or opt-out. And at that time, councils could say, they had a one-time chance only to opt out, to say they would never allow for any cannabis retail facilities in their municipality, or if they remained silent on it, they could opt in, meaning these types of retail facilities could open in the community subject to the licensing from the province. South Glengarry at that time chose to opt in, and they chose to treat cannabis retail like any other retail store. So we actually now have 2 stores located in South Glengarry, specifically in Lancaster. Also, the Farming and Food Protection Act does not currently define cannabis production as a normal farm practice. If it were to do so, municipalities would not have the ability to regulate the use of land regarding cannabis production, as it would be protected under the Farming and Food Protection Act. So we also have the provincial policy statement that we have to conform to anytime we're looking at new land use planning policies or land use planning decisions. So the PPS provides policies to promote rural economic growth, employment, land use compatibility, and the protection of agricultural lands for agricultural uses. Any municipal land use planning must conform to all of these policies. And Public Health Ontario found that there were no adverse health effects to the odors emitted in cannabis production. However, the odor may impact the quality of life and the sense of well-being for an individual exposed to them. So as much as we might not be impacted from a health perspective, we certainly might not care for the odor. We might not, appreciate that use being in close proximity. Another item to talk about when we're looking at these types of facilities is most cannabis cultivation and production occurs indoors. Depending on the structures being built or repurposed for cannabis production, they may contribute to light pollution, and alternative building designs should be considered to reduce the impact. Oftentimes when you see these types of facilities, there's no windows. They're very solid building with high security, so then all the lighting would be on the interior. As for noise, most noise in cannabis production is a result of HVAC equipment, and which would be used to manage the indoor climate of the facility. And the miscellaneous noise may also be caused by alarms, machinery, delivery, vehicles, etc. Neighboring uses may be impacted by these sources, therefore adequate buffering should be considered. But really, there's probably no difference to that type of facility like there would be in comparison to other manufacturing or retail facilities. We also want to consider setback distances. So due to the potential for disturbances such as your noise, odor, and illumination, it is recommended to establish setbacks from sensitive land uses such as residential or institutional uses. And licensees must demonstrate that the growing site is not adjacent to a school, a public playground, daycare facility, or other public places that are frequented by minors. We also would want to consider landscaping and buffering. The security measures may include fences with barbed wire for large-scale facilities, but may create visual discord with rural lands surrounding them, which can be mitigated with an adequate visual buffering and landscaping to reduce the institutional look. So it's something we could do is ask for some trees to be planted, hedges, things like that, if and when we have a facility that's proposed that would trigger that type of security style fencing. For the security and crime aspect, while there have been concerns regarding crime surrounding cannabis production, the required security measures will provide restricted access as well as visual recording to deter crime. And from a land use compatibility perspective, when assigning zones where cannabis production, cultivation, and processing are permitted, compatibility with surrounding uses should always be considered, and it should be a priority for us so that we're not creating incompatible uses. So in August 2022, so just a few months ago, the United Counties of ST&G passed an official plan amendment to allow local municipalities to permit a licensed cannabis cultivation and production facility in the rural district, agricultural resource lands, and the employment district lands. So now it's time for us to update our bylaw to bring it into conformity with the official plan. So according to this OPA, a licensed cannabis cultivation and production facility shall be directed away from mixed-use corridors, including areas with tourism and highway commercial uses. Also, when cannabis production, cultivation, and processing are proposed as an agricultural use, an existing building cannot be retrofitted without a change of use permit. So what that means is you need to obtain a building permit under the Ontario Building Code to change the use of what that structure was originally built for is now being accommodated for a different type of use, generally with employees inside to look after the products. And when a proposed industrial use is, must demonstrate conformity to the land use compatibility guidelines prepared to the Ministry of Environment, Conservation and Parks. And what these guidelines are is they set minimum setback distances based on the use between light, heavy, and or light, medium, and heavy industrial uses. So currently, our zoning bylaw does not contain any specific provisions for cannabis restrictions for production and processing, which is why we put the interim control bylaw in place to allow us to deal with some concerns and hopefully establish the policies that are needed that make sense for South Glengarry, that protect our residents as well. And the definition of agricultural use in our existing bylaw does not include facilities such as commercial activities related to agriculture, such as manufacturing and processing activities, and the industrial and rural permitted uses that may accommodate varying scales of these facilities, including agricultural industry as a use in industrial zones and agricultural uses in greenhouses in agricultural zones. So that brings me into what's being proposed by administration. So first of all, we want to insert the definition of cannabis in our bylaw. As I mentioned, we have no reference of cannabis currently. So we would define what cannabis means, what the product is, and then this is the proposed definition, which marijuana shall also have the same definition. So cannabis means a cannabis plant, including the phytocannabinoids, I don't know if I said that perfectly, produced by or found in such a plant regardless of whether that part has been processed or not, and any substance or mixture of substances that contain or has on it any part of such a plant and any substance that is identical to phytocannabinoid produced by or found in such a plant regardless of how the substance was obtained. And it's important for us to define that so that people understand the difference between that type of plant versus hemp, let's say. I've had a lot of phone calls, a lot of questions from the public saying, do we treat hemp the same as what we would treat cannabis? And the answer to that is no. We're also adding a definition for air treatment control, and that shall mean the functional use of an industrial-grade multi-stage carbon filtration system or similar technology to reduce and or treat the emission of pollen, dust, and odors expelled from a facility and sized accordingly in comparison to the facility it serves and as designed by a qualified person, and generally that is an engineer. We also want to put a definition regarding greenhouses in cannabis. This is certainly common in Western Ontario, especially where there was a lot of tobacco production. So we don't see that too much in Eastern Ontario, but it is possible that we could have a proposed greenhouse be erected. And it shall mean a building whose roof and sides are made largely of glass or other transparent or translucent material for the growing of cannabis plants in which the temperature and humidity can be regulated for the cultivation of cannabis for subsequent processing and sale. Now I'm going to get into a few definitions in terms of the different facilities. I'm not going to read every one of these definitions. It can be available either through our office or on this video. But what we're getting into is just a few different types of facilities. So the first one being a cannabis cultivation and production facility that's licensed, and it's done so in accordance with the Cannabis Act. Then we also have a cannabis micro cultivation and production facility, and that basically refers to a smaller type of facility that is limited to 22 square meters of gross floor surface area. We also have a cannabis micro production. Again, that's also licensed, and this is regulated on the maximum of 600 kilograms of dried cannabis in 1 calendar year. Again, this is licensed, all regulated by the federal government, by Health Canada. So if these licenses were issued, we now will have these types of facilities listed in our bylaw, so we know how to accommodate the individual proposed businesses. And then we also have cannabis nursery, production and processing facility, which is also licensed. And this one is limited to 50 square meters of gross plant surface area or canopy, and is intended to allow for the creation of a starter plant materials, seed production, development of new plants, etc. We currently have a definition in our zoning bylaw for sensitive land use, but we are proposing to amend it to add in playgrounds and place of worship. So sensitive land use is important to define in any zoning bylaw because you could have different types of uses that are outside of cannabis that could have air emissions that could negatively impact an abutting property owner, or even noise emissions. So this means a building amenity area of outdoor spaces where routine or normal activities occurring at reasonable expected times would experience one or more adverse effects from contaminated discharges generated by a nearby facility, and includes a dwelling, day nursery. We're now adding playgrounds, places of worship, and educational or health facility. So now we're getting into kind of the meats and potatoes and how this is going to work. And we're proposing setbacks that are very similar to many municipalities in Eastern Ontario, and we'll have 2 municipalities that will be very consistent to what we're proposing in SDG. So we want to establish setback requirements that are consistent with other municipalities in the United County's recent OPA. And what we're proposing is that 70 meters from any residential or institutional zone and 150 meters from any sensitive land use where air treatment control is used, and 300 meters from any residential or institutional or sensitive land use where there is no air treatment control. So of course, if it's going to be more odorous, we want a much larger setback. 300 meters is almost 1,000 feet. We also want to ensure that all facilities will be subject to the site plan control process. This will be an amendment to our site plan control bylaw that will come in the future. And what that means is if we happen to have a structure that's going to go through a change of use permit to become this type of facility or a new facility proposed, we want to be able to put them through the site plan control process to regulate the location, the setbacks, the lighting, security, fencing, all of those things will be important for us to look at as a municipality to ensure that they're creating a safe space. And what we're going to do is recommend that it be included, these types of uses, as I mentioned, would be included in the industrial, agricultural, and rural zones, subject to meeting the setbacks. And we'll have a draft bylaw brought to council on December 5th, 2022 for approval. And I am hoping to do first, second, and third reading all at once based on the information I just presented to you. So that was a lot of technical information. I'll do my best to answer your questions if you have any. I'm not a cannabis expert. I'm learning, I'm getting there, but I probably will never be an expert. So I'll do my best.
Thank you, Mrs. Haley. I'd like to open the floor to councillors and public, so we'll go first to Councillor Bougie, and then Councillor McNell.
There we go. Okay. Thank you, Mr. Mayor. So I guess the history, I remember on council, we did decide to opt in as a township, being that we felt it was heavily regulated. And we do now have 2 facilities, retail facilities in the township, which is, I mean, it is what it is, right? So it's good for business. My question, I guess, would be with the control bylaw, or interim control bylaw, can we set the framework if we want to add additional, I guess, restrictions onto these facilities? It seems like it's a case-by-case basis because there's so many, there could be so many different potential facilities. So I guess that's, but I do like how you brought up the buffers for adjacent property owners or facilities such as schools and whatnot. So I feel like that's a very important component to have in there. That's just all my own comment I wanted to bring.
So through you, Mr. Mayor, we can impose additional restrictions on what administration is already proposing. So basically, to summarize that, we're already limiting it to just the industrial institution, or excuse me, industrial, rural, and agricultural zones. So we will not allow these types of facilities in any residential zone or an institutional zone, or of course, any environmental protection zone. And hopefully, that will work to benefit the residents because it should be able to meet more of the separation distances. Although we do have some light industrial zones that are in close proximity to houses, and you'll find a perfect example of that would be the southern end of Richmond Road, where our industries start meeting the residential uses. We also have that in Hay Road area, Summerstown Station. So that's one of the reasons why it's really important to put those setbacks in place so that we protect the residents. So for example, if you don't have any air control, quality control, then you're looking at the 300-meter separation distance. And then if not, you could be as close as 70 meters or maybe 150 meters, depending on the type of facility. That's been mostly what the province has been regulating. We could always try and go, we could do further setbacks. We could also not allow the light industrial zone to be included. We could limit it to only heavy and rural industrial. In our municipality, we actually don't have any property currently zoned as heavy industrial. We just don't have a lot of manufacturing that occurs that needed that designation or zone. So if, for example, if council wanted to eliminate the light industrial component because of the potential proximity to houses, it would mean then that if we had a company interested, they would do a site-specific zoning amendment to seek permission from council. So that is food for thought for you. If you think I'm being too flexible, I look forward to that feedback.
We'll go to Councillor McDonnell and then Councillor Jaworski after that.
Just 2 questions through you, Mr. Mayor. One, there's a particular property that comes to mind down around Curry Hill. When it comes to highway commercial, how does that kind of play into this as well? I hadn't seen anything mentioned there.
So through you, Mr. Mayor, that is an excellent question. They're not going to be permitted in the highway commercial zone from a cultivation, production, and processing perspective, only because there's too many humans that tend to visit the highway commercial zones or work within the highway commercial zones. So it's not meant to be the place for them. Retail obviously is very different, so that would be permitted and again regulated separately from this. But we're not recommending it to be in highway commercial at all. If, for example, if you use Curry Hill area and you feel that there's a property that's maybe a little isolated and could meet the setbacks or even beyond what's being proposed, they would have to do a site-specific zoning amendment. And the reason for that is because when, in the Curry Hill area, if the other properties around it are zoned highway commercial, that means they already have uses as of right that they can walk in and either build or occupy. And now we've put them beside a potential production facility that may then result in incompatibility with odor and emissions.
Through you, Ms. Mayor, and yeah, no, thank you for the answer. Just, I was just thinking there is quite a bit of rural mixed in along a lot of residential and highway commercial there, so there was potential. The other question I had was, and I don't know if this is even possible because Hydro is a privately owned company or privately operated. It's not necessarily here in South Glengarry, but in other surrounding municipalities, there's been issues with heavy pull on the infrastructure that Hydro has. And generally, I'm thinking the ag side of it. If, say, one of these facilities drawing a lot of power was to go up, say, next to my elevator, I could potentially, if there was a lack of power, I could start blowing motors. So how do we protect our existing like commercial and agriculture operations that are running right now? They could potentially have suffer kind of some of the consequences of that. So I don't know if there's a way to circulate hydro to be sure that there is the power load necessary to run one of these operations and for them to have future expansion, but just a comment I had.
Okay.
Thank you, Councillor McInell. Councillor Jaworski.
Thank you, through you, Mayor McDonald. Ms. Haley, I was wondering if you could speak to how what's being proposed would, I know it can't be applied retroactively, but for example, there are certain areas of the township where we did receive complaints. I don't know if I can get into specifics, but if you could talk about how this proposed bylaw would or would not have impacted what occurred there, and do we think it would have made the situation better or not? Thank you.
Through you, Mr. Mayor, yes, that's an excellent question. And you heard me talk about two different areas in our municipality where we would have a light industrial zone that could maybe accommodate these types of facilities that would be in close proximity to our residents. And so any one of those structures could be applied for to be utilized for a production facility. And so that's one of the reasons why we want to amend our site plan control bylaw to make sure that we include these types of facilities, because we want to look at the distances between the proposed facility and the residents. 70 meters really isn't a lot of distance, but when you're in the 70-meter range, we're obligated to make them put in the air quality equipment to ensure that that's hopefully removing a majority of the odor. And there's been studies done elsewhere in the province that proves that that really does make a big difference in terms of reducing odor and possibly eliminating odor. But that's why I mentioned 70 meters is still not a really, really large distance. So maybe council wants to consider removing light industrial zones, because that would take away our Richmond Road area, for example, and our Summerstown Station area, for example. We don't have a lot of industrial zones in South Glengarry just because of the nature of our businesses. And people would be required to go through a site-specific zoning amendment. But getting back to your question specifically, I think it's achievable, providing we have a cooperative business owner that wants to follow the rules. And with now having the provisions in our zoning bylaw, if approved, and then having the provisions in our site plan control bylaw, we will have teeth, for a lack of a better word, that we didn't have previously that would hopefully require the individuals to comply.
If I may, yeah, no, because while you were speaking, I was just looking again at Summerstown Station. Yeah, I mean, they're very, very close. They're essentially neighbors, budding neighbors. So I guess considering we have that experience, I just want to make sure that that specific experience informs how we're moving forward. So if I understand correctly, in this case, if there were to be cannabis production in that light industrial area, they would fall under they would have to have the HVAC, they would have to implement that. Mm-hmm. Okay.
If I can add to that, Mr. Mayor, if we use that spot in Summerstown Station as a perfect example, because honestly, they're not going to be able to meet the 70 meters because the houses are direct neighbors. If maybe as you go east down the road, it'll be a little easier, but not certainly in the main area where we have a couple of industrial buildings. So to me, that site is no longer a probable site. Now, again, anybody can come for a minor variance, they can come for a zoning amendment, but we'll deal with that on a site-specific basis. But hopefully it would deter this type of use in that location because of the 70 meters and then the cost for their air quality control.
Are there any comments from the public present? Okay, great. Well, then I guess that summarizes that new business, and we'll look for adjournment. Can I get a mover and a seconder? Moved by Councillor MacDonell, seconded by Councillor Bougie. We will adjourn this meeting call of the chair at 6:41 p.m.